It has been a long day, and he used to wear a lot of hats. Ladies and gentlemen, I'd like to apologize for being late. In the old days, somebody came up with the idea to have the prosecutors also in Postępu 3 Street, which is called Mordor in Poland, because it's a constant traffic jam driving here, and on top of that there's refurbishment. That's quite a challenge. Guests in the last panel need no introduction. Adam Bodnar, Konrad Siemaszko, Helsinki Foundation, and Paweł Czajkowski, Legal Department Head of Agora. And the debut of you in the Constitutional Tribunal as a young lawyer. It's the last panel, but the most important at this conference, because we've got the guest who is the main addressee of what is happening, what has happened in the European Union. The directive that comes into force, 2 years for implementation ahead of us, and Council of Europe's recommendations, which can be very helpful in implementation. Paweł Czajkowski is the first person requested to tell us about the questionnaire that was carried out among local publishers, local journalists, when it comes to implementation of SLAPs. And then Konrad Siemaszko, Helsinki Foundation for Human Rights. Not only did he map the areas of law that should be changed, but the foundation came up with the idea of proposals for changes, and then minister to you, waiting for you, for your opinion. What's your take on all these proposals, and can we count on swift implementation? Maximum implementation of the directive. The presentation will be on the screen. I cannot turn around, so I don't have the second screen. Let me move around in order to be able to present. Ladies and gentlemen, the idea of questionnaire was to make it possible for media representatives, editors-in-chief, broadcasters, journalists, and those working in editorial offices to address SLAP problems. Not all of them were able to reach us and participate. And we had a feeling that the reality meets our expectations. It is not uniform the problem of SLAPs. There is a different perception. And I believe that thanks this questionnaire, we have captured the multi-faceted nature of SLAPs, not only journalists of all Poland magazines, but also of media at the local level were taking part in this one. So we can refer to a number of things that we found out in the questionnaire with reference of the problem. I like the notion that Dominika used at the beginning of the meeting, that Agora is supposed to be a midwife in delivering the message related to SLAP, so it is quite nobilitating. I'm very happy to be able to present it and give you that food for thought. Let's speak about the results of the questionnaire. Let's see who's been taking part in the questionnaire. And at the beginning, I'd like to thank the co-organizers, the Associations of Local Newspapers and the Publishers Chamber that propagated the questionnaire. The questionnaire was by no means easy in its format, because there was over 60 questions, including the open questions, and I've got the feeling that all the people required our thanks for complementing the questionnaire, because open-ended questions give us the most information. What is the greatest problem of SNAPs, in addition to the obvious institutions that have been famous or infamous, that have been in the general domain. One of the first questions relates to the ground that media representatives came across SLAPs. We have indicated press law institutions, Not only do we speak about civil law, panelists indicated it very well in the previous panel, because correction was most often stressed as a problem that has been identified as a SLAP, or the institution that is associated with SLAP. There is a series of reasons, and I want to recapitulate the reasons. They were recapitulated very well in the previous panel, and there is a plethora of them. And every concept, a question for correction, whether this should operate in the Polish market. And there is a number of elements that I'm going to speak about, because sometimes they may request to publish untrue information. So courts oblige press and media houses to publish something that is not true, which even aggravates the aggravation, because the press material, the origin plus press material was unrobust because of this publication. So no matter how much education we provide, no matter how much we speak about the social problem among the general public, the publication of the correction, it tarnishes the image. That it was not wrong material. The unreliable material. So there's the titanic work of Gazeta Wyborcza, and what was highlighted on numerous occasions is the time that is required to deliver a correction. Clashing with 7-day response time, it paralyzes the editorial team's work. We have further stage discussions with practitioners, and they find it difficult to imagine a situation to write the response to correction without legal support, and we meet on court rooms and discuss it. The local editorial teams may collaborate with legal houses. The bigger one have internal departments or legal departments. It's paralyzing for the local media. Speaking about the local media, financing SLAPs from public resources. This has been indicated by editors-in-chief and editors in general. Public financing notion is multifaceted. Why? Because on the one hand, we speak that there are ministries, state treasury, companies and institutions, local government institutions finance SLAPs. But we don't say that it is much more than just services. There's a lengthy process. So if we have a situation that civil litigation may take 6 to 8 years until court ruling, so we need to realize that publisher must be secured on the side of legal services. It is not only about right or plead, but support. If there is multiplication of these proceedings, it means that there is a huge part of the budget that is earmarked for constant legal services and constant legal care. What is really, what skips the discussion, what is also shocking is the fact that there are people working in different offices, man SLAPs. Not only do we have the public money that initiates SLAPs, and the money is earmarked to produce SLAPs, but this is the state budget that runs the apparatus of pressure. So people should be working for the benefit of the general public and think about positive things. They serve the private business of particular interest of particular offices. So this is public media or public finance for the SLAPs. And one point of view that is more obvious, SLAPs that are associated with penal court institutions. And there is a theme. Some of the respondents have public administration organs that perceive SLAPs. There was the discussion panel number 4 when we were speaking about market regulators, including the Polish Broadcasting Board. I'm going to tell you more about this because it was duplicated and reflected in our questionnaire. So let's start with SLAPs into penal proceedings. Our respondents have indicated SLAPs related to 112 and 216 articles, infamous articles that will be on everybody's lips. I'd like to share with you two elements that are very important, and the other one is less obvious. I was very happy that on the first of the conference we have slap shaming. So not only slap is done through legal proceedings, but there is also public relations and the witch hunt. So the person who is the respondent has to explain why slap or penal procedure was initiated. Many respondents indicated that this is the journalist that is shamed. They have to explain that not only are they unreliable, but they are the respondents, they are charged. Information flow and legal awareness, we've got a situation that it's difficult to carry the burden not only from the legal but the social point of view. And what is also obvious, what is worth saying, these penal proceedings are initiated as revenge. It is not to show something in civil proceeding, not civil proceedings, but penal proceedings, but it's a revenge. They request the highest possible compensation, and the courts are less competent in libel or defamation processes. So personal protection rights, there are local courts that decide. In Poland, these are the lowest level courts that do the hearing, and they are unable to carry the burden. I'm nearing the end. Public administration bodies, there's a trio, and there is record breaking when it comes to this activity against media, the National Broadcasting Board, and I'm going to have one more minute. Local government bodies, they initiate litigation because they are the public bodies that are not interested in the publication of negative information themselves, but there was repression. And tax offices that act against publishers to intimidate them. When speaking about the broadcasting board on this freezing effect, much was said yesterday. What is worth paying attention to are the aspects, just like the correction, are not that obvious. One of the questions indicated is the form on the National Broadcasting Board, and use the form for the viewer. It can be the viewer and anybody, even those who haven't seen the program, they can file a complaint and they may request them to respond to it. It is the same effect as the correction mechanism. Brigitte Grysiak was speaking about it. It was a case of TVN. It's a big machine. That's an avalanche. Not only lawyers, not only administrative staff spend hours to respond to this absurdity, otherwise they are fined. And Article 18, that is again infamous. So what is the message of our conference? Is that, as Professor Kowalski said, the head of the National Broadcasting Board to have the cognition of courts of law, whether the publication of press material was justified, whether it was reliably made. This is the problem that we face, and the scale is even increasing. So if we were to say what may cause a chilling effect among journalists, our questionnaire shows that this is the one associated with Article 18 related one. There's a tendency to focus on a number of bodies in the market. So we don't have to name the publishers that were not the subject of an assessment, or the assessment was always positive for them. And there is always the ones that are targeted, and the offer of officers watch every minute. There is disproportional use of these tools, and this chilling effect is what we are asking about. I'm nearing the end. Article 9 of the directive. We asked publishers and broadcasters and journalists what was the greatest support. It was ongoing support from the legal house and NGOs support and the possibility to get support of NGOs for at least 10% of the participants of this question. It was perceived as the key support in this very difficult support that is facing slabs, and therefore it is a very important element of the directive in the Article 9, which indicates opening and opens the path for NGOs to join in the proceedings and to be present in slab cases.
When it comes to its onerous nature, from the point of view of administrative activities, it has been evaluated as low. However, some entities have not experienced slabs. It's interesting to say that their onerous nature is similar to the cases, to the slabs based on property rights. We need to remember that throughout the proceedings, and there are several hundred of them, because none of the people experiencing slab have encountered the notion slab as such, we can see there is much space to focus on training activists, journalists, prosecutors, and judges. We requested intuitive assessment of some potential helpful tools. Extending the directive on extending transborder issues to local ones. However, reduction of costs and covering the costs by slapper, demonstrating that this is not slap, and the possibility of early dismissal were evaluated as high. So the directive responds to the needs of the evaluating parties. Taking the opportunity that we do have the minister here, I would like to refer to some cases that are not related directly to slabs but are problematic. Refusal, denial to access public information, not providing accreditation to independent media. This is a common problem. I would like to refer to the issue mentioned by Roman in the first panel. It's about silencing criticism and prosecutors' offices not willing to handle the cases of press criticism. It's less popular than suing someone for insulting religious feelings. Slabs and phenomena around slabs occur at various dimensions. The opening of the discussion on some civil or penal as well as administrative proceedings show that the scope should be extended. Thank you very much. Thank you, Paweł. That was really brief. Your research results overlap with what we have just heard, so you have just summarized the conference. Konrad, what comes next? We have heard about problems, about problematic and challenging aspects for local publishers, but slabs also apply to activists. What ideas do we have to implement the directive to make it effective? Because in its very sense, it's not really so. I would like to summarize the direction of changes we are working on. Ladies and gentlemen, I am honored and delighted to be in this conference, bringing together so many people, knowing slap cases so deeply, and having the minister here. I have the opportunity to present the directions of changes to the regulations towards implementation of anti-slap directive. But before that, I would like to refer to this, to the pathway that took us to the recommendations, and I would like to describe successive steps we hope for. The work on the recommendations was preceded by analyzing the current national law and its implementation practice, both regulations used for slapping as well as instruments that could be used to counteract such practices. It was a systematic analysis of case law, but also on many years of the Helsinki Foundation within assisting journalists and activists in this respect. So the initial works started quite a long time ago. I'm very satisfied to present the outcomes in the presence of people who established the first program to combat such cases. The directions for changes have been inspired by the European Court of Human Rights case law, and also the best practices of anti-SLAPP law from other countries, including the project, the civic project of anti-SLAPP working group. However, we wanted to get good insight into SLAPP practice. That's why we carried out initial consultations and group interviews with judges, attorneys at law, and lawyers who have been representing journalists and activists for many years. We also talked to prosecutors to find out some weak points at different stages of court proceedings we should overcome to make the implementation effective. We also had the privilege to present our findings to some academic milieus. Professor Ewa Łantowska, Professor Sadurski, just to mention a few. We would like to present a brief summary of some initial proposals. We hope it's going to provide an impulse for successive discussion on the directive implementation. We want to carry out broad discussion and consultation. Towards the end of June, we'll present a more detailed document presenting some points of the discussion. We also hope for future work together. Together meaning the whole environment involved, all involved stakeholders and the ministry. Moving on to the recommendations, we would like to say that the major one is related to specific procedures of working on the anti-SLAPP law. We would like the discussion to cover the broadest possible range of stakeholders, including legal experts and people who fell victim of SLAPPs. We were very happy to talk to journalists, to activists, and we do believe that scientists, artists, trade union representatives will also be willing to get involved. We would like to initiate the discussion as quickly as possible. Dominika Bychawska-Siniarska mentioned that member states have 2 years to implement the directive, but SLAPPs are an urgent issue in Poland. Recently, we have had some unprecedented cases, but that's not going to put an end to this topic. The 2 most famous cases were used in Poland to promote SLAP long before the notion became famous in Europe. One was related to Allegro versus activist, and another one, Henryk Stokłosa versus Krystyna Almanowicz. It was mentioned yesterday. The two examples show we can expect more cases like that to come. We believe that Poland's experience in recent years can give grounds to developing powerful law, setting standards for other member states. The most important objective is to implement the directive to ensure protection against SLAPs in Poland. If the implementation is limited to the minimum, it will only be in a document in paper which will simply not function in practice. The implementation of the directive should take into account national civil cases as well as administrative and penal ones. We simply want to avoid some gaps that could encourage reaching into these areas that are not covered by the directive. Definitely, it's not only about procedural cases, but also to tangible law or substantive law that will always be chilling the public participation. Defining SLAP, that would be the first case for courts to recognize whether the case is really a SLAP. Based on our experience, we know that we need to define what it means that the case is unfounded, manifestly or completely. This is an indispensable component in the definition. Without it, the protection against SLAPs would go in vain. Both the directive and the recommendations include a catalogue of premises helping courts recognize what a SLAP is. We also need the discussion whether the premises shouldn't be extended to cover some components we have already mentioned. Based on our practice, we know that very often it's about abusing procedural law by the slapper. We have the institution of early dismissal. None of the institutions offers any safeguards corresponding to the directive's requirements, hence we need legislation changes. There are some components that emerge from our analysis and conversation with specialists. They need to be guaranteed, but you also need to remember the other party, meaning the right for fair trial, but also the freedom of expression, and also the claimant should have the right to be heard. The directive includes specific precautions that can be used alternatively. We understand we need a law that would let courts use a broad range of potential measures. Only this way can we choose a response adequate for the specific case, whether it should be a fine, punishment, compensation, higher cost of the proceeding, or publishing the statement. When we implement EU directives, we need to understand what compensation or damages or tort is. It will definitely require further discussions. Another aspect often mentioned is excluding active legitimacy of the state treasury and territorial government units in cases related to protecting someone's reputation. There were hundreds of such cases against state treasury entities. And it's also about implementing the sentence of the European Court of Human Rights. It is pivotal, next to procedural cases, to revise the penal law regulations used for instigating SLAP lawsuits. Even the best changes to the procedures will not suffice to protect people against SLAPs. We need to decriminalize libel or defamation. Perhaps it should be related to some changes in the law, such as in the statements of claims. We should also recall strengthened protection or insult against body, as well as penal sanctions for insulting national symbols or religious ones. The longer version is available on our website. I only presented the summary. If you have any ideas or comments, do not hesitate to send them to us. We hope that the initial ones will stimulate further fruitful discussions. Thank you, Konrad, and thank you for your hard work. You entered the subject matter deep. I'm looking at the minister once you hear about another urgent topic. I know it's a problem, but I know you will manage. This is a common understanding that we need to implement the directive. It will simply mean the revision of our regulations to find out what ensures freedom of expression. Ladies and gentlemen, distinguished guests, thank you very much for inviting me. That's a huge challenge. A challenge how to approach an issue of such huge interest, both practical and theoretical. As for SLAPs, I have cooperated with the Helsinki Foundation. The Agora case is very important for me. Henryk Stokłosa, his civil lawsuits based on Article 212, that was the first case discussed in the Polish press. There was a long feature in duży format presenting the perspective. Our domestic reality has changed significantly after 2015, when SLAP started to be used by public authority bodies, by state treasury companies. It's also important to say that Polish SLAPs applied to interference or activities of state-owned rather than public entities. I'm not saying that public entities do not use it, but the major problem of ours applied to public entities. I feel that at a certain point I encouraged Okopress to take care of it. I can see representatives of Okopress here. I don't remember if it was Okopress or Archiwum Osiatyńskiego, but that was generally this milieu. For some time, I was a member of SLAP expert group. We were working on the directive when I tried to present the argument saying that TVP, prosecutor's office, and state treasury companies are the major threat. Nobody understood me. It was as if I was talking about different social and political reality that representatives of other countries could not understand, that these were corporations were typically responsible for slap lawsuits.
And I've got the feeling that the directive does not respond to that fully, and this transborder limitation is a bad one, but this transborder thing will be like implementation of a whistleblower directive, 1937. Theoretically, it's narrowed to aspects of European law application, this whistleblowers. But once you implement it, it's general use. It will have effect for the whole legal system. If it is transborder limitation, the implementation will have to result in broad scope attitude to the problems of slap mitigation and combat. I'll tell you about the details in a moment. I won't limit myself to general comments. Ladies and gentlemen, from the point of view of slaps, there is a new circumstance, quite unexpected. Ever since I started to be Minister of Justice, the ministry had a number of slaps and reporting institutions also. Dominika, my advisor, took the burden not only to review the cases in the context of relations with the legal houses that assist us. There was a challenge to get the knowledge from the legal houses that represented the ministry. It's not like, you come in, there's Minister Warchoł, and he says, there are all slaps and all motions that we filed. That was quite a big machine. So getting access to information, getting knowledge about the ministry that is the party of proceedings, it took us some time. But in many cases, we are able to stop the proceedings in the appellate courts or withdraw our motions. There's a practical thing. One of the institutions reporting to the Ministry of Justice, but we cannot control it directly. The Law Justice Academy that sued wyborcza.pl, and there was the binding resolution that discontinues. There is the time for the Supreme Court, so how to shape relations between rector commander of the school in this context, saying that he should discontinue the thing. These are the challenges that we face. They show the scale of the problem. I'm in this privileged position. I know what it is all about. You don't have to explain or convince me. And we've got state treasury companies. Not necessarily do we have this reflection process. Only recently there's been a new board of Pigen Olen, the new president of board, and he discovers these problems every day. Great problems. So slaps seem to be small. I don't want to be flippant or depreciate the sense, the meaning, but these are incomparable to the situation when we have a daughter company losing 1 billion zlotys overnight because of there's been some kind of ill management in purchases. So when we discuss slaps, we should remember that this is not only the ministry's responsibility, but public institutions' responsibility, first and foremost state treasury companies, to make this review and to withdraw the motions, especially when these were the attempts to silence criticism. From the point of view of slaps, there was a specific situation. At the beginning, when I became the minister, I apologized Judge Kossak-Janusz, who won with Zbigniew Ziobro, and it was my duty to publish apologies, and the problem was that the minister didn't publish it for some time. It was difficult to refuse. This is one of the extra aspects. Speaking about SLAPs and directive implementation, what is Polish specificity? I wrote an article, me and Dr. Aleksandra Gliszczyńska-Grabias, SLAP in academic freedom. Why am I saying this is Polish specificity? Professor Wojciech Sadurski was the victim of a number of SLAPs. In case of Professor Sadurski, there is a doubt whether he was targeted as academic, teacher, or participants of public debate. Pretty advanced in his knowledge. This is one example, and the other example, the ones against Professor Barbara Engelking and Jan Grabowski. SLAP were to silence the debate about questions related to history that are important and history research. No doubts. And the position paper of the Helsinki Foundation, freedom of the academia, university and research should be protected against SLAP. But there is an important aspect to make academic milieu sensitive to these problems, that the problems may appear in the context of academia and possibly in the context of further activities. It is worth thinking about the Ministry of Education and Science. Legislative changes, we cannot forget it. What was interesting, I asked one colleague who is an excellent expert on civil procedures 15-18 months ago. I asked him about the civil law doctrine, about SLAP implementation. If there is any work, I could see the wall. No reflection. What to do with that? So experts on civil proceedings learn now that they have to do something about this. And Polish law needs to be corrected. It's the problem of divergence of two worlds. People into human rights and freedom of speech think that what they do is, everybody's familiar with this. And there's another bubble of dogma that live in a kind of different world dealing with different problems. And these twine shall never meet. And I'm very happy that you involved Professor Dziurda. He's a very important person. He's a big name, and he's got the impact on doctrine creation. In the context of the doctrine, when preparing to today's meeting, I requested to prepare a note what to do in the context of SLAP directive. I requested via Ms. Rudzińska-Bluszcz, civil code proceedings, how to approach it. What was a surprise? I got a professional note, but if we have a regulation 191, paragraph 1 of civil code, if the litigation attachment shows that there is unjustified, ungrounded, the court may repeal, may dismiss, and it can be used in SLAP. And the second argument, we've got Article 4, number 1, which foresees the institution that fights the institution of abuse of process laws. So we can cope with SLAPs on these grounds. or even decide about the questions, financial fine for this person, require to return the costs, because this meets the objective of Article 14 of Directive. The author of the note doesn't act in ill will. It's a deeper problem to solve, that we look for some general regulations that has been used now, and we solve the problem. We cannot go without defining what SLAP is. We cannot go without introducing a detailed test that the court has to run in the context of SLAP, deciding whether it is yes or not, and taking radical decision to dismiss it early because somebody is deprived of legal procedures, court procedures. So we need to have arguments. General interpretation of regulations is not enough. These that were created for specific purposes, we need to grab the bull by the horn and introduce it to the legal system. So we should have tough regulations. Who's going to do that? It will be the Coding Committee of Civil Law at the Ministry of Justice. There is no better body than this one to carry out this discussion. It is headed, the head will be appointed. Professor Marek Safian will be appointed. This person is sensitive to human dignity, civil laws and basic rights standards and European Union laws. And I know that there'll be a number of people who are practitioners and theoreticians when it comes to civil litigation. So I believe that they can cope with this, with preparing these very well. And I hope this will be accompanied by collaboration with non-governmental organizations. This is one part of the problem. Attitude to civil code. How to cope with the problem that I have been dealing for many years. I look at my Helsinki Foundation colleagues, 20 years. I started in November 20 years ago. I remember one of the first cases. Dominika helped me, Dominika Bychawska, Marian Maciejewski's case. I remember this. It was November 2004. Me and Professor Rzepliński and Professor Hołda, we were going to Opole, the district court hearing about Marian Maciejewski. Article 212, 20 years after, it's still alive and kicking and present in our legal system. So my idea is, I made a formal letter to the Codification Committee of Penal Law. Professor Wrubel knows this. He is to delegate 2 or 3 or 4 people to deal with 212 and 216 of Penal Code, and Civil Committee will delegate people from personal rights so that they collaborate. They do away with the regulations that foresee penal responsibility and strengthen civil responsibility. Not in the sense that it's more restrictive, but in the sense that we have the question, as is the context of SLAP, to think about the gravity of the burden of proof, procedures, disclosure of anonymous haters or anonymous people that infringe personal rights. So there's a bigger reflection on costs in civil litigation. The use of 212 is the way to protect reputation. It is not that people just want to use 212. Sometimes it is not possible to disclose the perpetrator's identity. So it should be coupled, to couple the work of these committees and work out. And another thing to be done, to think about regulations of cost reimbursement and fines on slappers. You cannot do it without legislation change, because this is extraordinary question. Not only do we speak about the basic cost reimbursement, but the ones increased when it comes to the scale of defense in slap cases. So free support system of legal help is insufficient. To reform it, we have to improve it, but I don't have the answer. Which institution should take care of this? It's quite natural that ombudsman, but the ombudsman has got so many additional tasks. How effective is that going to be? How effective will be the support and protection? In the context of SLAP, you might have noticed that I haven't spoken about corrections, the role of the broadcasting board, broadcasting council. But identity and competences of other ministries should be respected. I am able to have good agreement with some ministries. I collaborate with the coordinator of special forces. On Monday there was a very important conference on methods of corruption combating, which is the result of our collaboration. And in the context of regulations of public media, correction on press law institutions, we have to wait for a new Minister of Culture and National Heritage to see how it is shaped. But I'm open for collaboration in this respect. And one more thing. It was about staunching press criticism and reaction from the prosecutor's office. I'm not surprised that prosecutor's office over the recent years didn't react to staunching press criticism. That was the setup, not to deal with it. But if dealing with this, attacking independent media and voices. And we are entering the new phase of prosecutor's office operation. I had the meeting of the labor unions, Article 35 on labor unions, staunching the labor unions' activity. I will fire to look through the analysis of preparatory proceedings in these cases, because it's a dead one. The prosecutor's office discontinues. The general prosecutors has got the right to indicate guidelines of the prosecutor, and this could be useful. Staunching press criticism, I don't know how much the proceeding was the subject of greater interest of a prosecutor's office. To finish off, today's conference and yesterday's conference we are getting rid of Polish presidency in EU. Tusk's and my opinions said that one of the priorities of Polish presidency is the role of civic society, to think about it in the context of democratic values defense. How much Polish 8-year-long lessons might be helpful to other countries defending against existing threats to European values. And as panelists said, We've got our own experiences. We should plan it so that we should have a review conference to implement the European Union directive.
I know there is still some time left, but member states will definitely be more advanced in the implementation. I feel that we shouldn't wait with the changes till the end. We've got our experiences, observations, and hence we should kick off. I believe it would be good if in a year's time, or even earlier than in April, we organized a review conference with the participation of the Ministry of Justice devoted to the subject matter. Member states could also share some experiences. I will be responsible for organizing justice and home affairs meetings under the Council, so I suppose one of these sessions should be devoted to it, regardless of NGOs, conferences, or those with journalist organization participations. I believe we know what to do, we have things to do, and there are plans for the first half of 2025. Thank you very much.
Panie ministrze, bardzo, bardzo dziękuję.
Minister, thank you very much. We have heard a lot of important documents we've been waiting for about 20 years. As for implementation of the directive, it is important to look at the Council of Europe's recommendation. There is a 10-point checklist for judges, and the definition is included, and it can be like copy-paste solution. As for presidency, it's good that we can show we are at the forefront and implement some aspects faster. There is going to be a large conference of the Council of Europe devoted to slabs, and in November, Poland can also present its activities. One question and observation, as you know how to handle it within the ministry. You've got representatives of civic society and SLAP working group willing to support you. Is it possible to consider establishing a working group at the Ministry on the freedom of expression? I suppose that the work already done could be used as the basis, and we could be included in the dialogue on working towards implementing the directive and its recommendations. For us, it's very important. As you know, our professional life is devoted to defending clients and ensuring freedom of expression. I believe that our practical approach that perhaps was missing in the note you received could be very helpful. Ladies and gentlemen, I believe that as for the Council of Europe's recommendation in the context of the role of judges, it will be important to review the curriculum and who teaches these aspects. For those who might not know, lecturers from the National School of were there because of some connections. However, including these topics related to the freedom of expression is definitely very important. I'm wondering what would be best, whether it's about working with the ministry or going towards establishing an interdepartmental, interministry team. Such teams focus attention of other ministries. And it could be important. The topic is important for the Ministry of Foreign Affairs in the context of building relations with the UN and the Council of Europe. If you listen to Minister Sikorski's speech, we would learn that our role is to present some standards towards other countries. That's why I suppose that once Ministry of Home Affairs knows more about Slavs, we could more easily identify such people, such victims. I also mentioned the Ministry of Education and Government Legislative Center. There are more ministries and departments that could be interested. And there are people who could join the interdepartmental team to share expert knowledge. Why am I talking about it? I know it would be good to say, yes, indeed, we'll establish such a team, but I need a moment to do so. I would like to give the opportunity for the codification committees to work. It's not going to be a lengthy process. It's no secret that everybody feels the need to work with the civic society. What about time perspective? We've got such a commission. This is a codification commission of. It's going to be established on the 8th of May. So just within very few days, the working groups should consider what to deal with. I will also encourage Professor Wrubel and Safian to begin with the general reflection and intensive meetings with civic society representatives. Thank you. I'm looking at other panelists. Konrad, Paweł, any comments, questions? I would like to thank you for the declarations, and I'm sure some members of the audience do have questions. It's a very good idea to create a common team.
Biorąc pod uwagę ten szeroki zakres prawa.
A broad range of anti-SLAPP law. A similar initiative could be a good idea, even if we expect fewer SLAPPs from the prosecutor's office in the context of creating standards for other countries and including it in our Polish law, including criminal law, could be a copy-paste solution for others. I can see some questions from the audience. The minister has 10 minutes for us. So we'll ask for the answers and we'll try to close. Jarosław Mazanek. One suggestion. The minister said he didn't know whether there were any attempts to silence press criticism, not mass cases, but there were always denials to instigate investigation. And the question, you mentioned that instead of 212, we should regulate the issue, how to defend yourself once you are attacked, especially by anonymous accounts. That's a well-known problem, anonymous haters. I have plenty of examples when the prosecutor's office requests a matter for legal assistance, and the answer is always no. how to solve the problem of unsuccessful assistance from Meta. As for the School of Judges and Prosecutors from Krakow, the KSIP you have mentioned, I also investigated the quality of the lectures, but I don't want to elaborate on it. I feel, listening to the minister and to the previous speakers and previous panels, that now there is the time, we have the opportunity to end 20 years campaigns. You mentioned 20 years of fighting for with Article 212. We used to have a shared campaign. I was also traveling to Opole with Dominika as part of our academic meetings. We were quite close. It seemed that when Mr. Govin was the minister but then it ended. So now it's important for me that some works have been initiated to close the 20 years long campaign. You also mentioned another campaign of the Chamber of Newspaper Publishers and Helsinki Foundation on local government press, and the Ombudsman also expressed his opinion on the subject matter some time ago. Is there a chance that this campaign will end as well? Are there any other questions from the audience? So, I would like to ask how we can support you. We know the ministry is open towards decriminalizing 212, but we don't want to blur the case when the draft act goes to the parliament. Are there any suggestions, solutions, if we may ask such a question? Thank you very much for the question. When it comes to attenuating press criticism, I can declare that I'm going to refer to the prosecutor's office to analyze the files, how many cases there were. It's not a major problem for them. Through the prosecutor's system, identifying the cases and analyzing the files is simple. We could also include it in the general trend of settlements and analyzing what our past looked like. As for Meta, Panopticon carried out some research on the quality of collaboration. It's about social anti-drug initiative. They had some experience in obtaining data and international cooperation. I don't know, perhaps it was, simply meant not to deal with the case, in fact. When at the beginning of my work, I requested a note, the argument was that the prosecutor's office was waiting for a response from Google and Meta. It's quite convenient. You can identify some aspects or some issues in a different way, but once you submit such a request, you're on the safe side for about a year. If there are 200 or 300 cases to deal with, people don't care if others ask. I'm sorry if the speaker is not using the microphone. We can hear them in the booth. Right, it's about seeking for other methods to reach the people, or it's about a creative approach to use the EU laws and regulations, or perhaps collaborating with the Office for Personal Data Protection. I'm not going to give you a clear answer to your question. However, it's worth analyzing it in the context of disclosing the anonymous perpetrators. It's also about creating new procedures through civil and legal procedures. Shifting it to the civil court that would be authorized to request some data could result in more power to obtain the identity data of perpetrators. You mentioned 20-year campaigns. However, I don't think the time went in vain. A lot has happened. We had some important sentences from Strasbourg and local. No, that was not a comment. It was a question. It limited the use of 212, but the problem still exists. It's striking that it still does. It applies to all stakeholders. We held a debate on 212. I was sitting next to Mr. Dera, and we agreed that something should be done. There was no space for the discussion with the Ministry of Justice, but now I think we do have the room for discuss. We've got intellectual space, and I hope I'll be my term of office will be longer than that of Minister Govin's one. So I hope I'll handle it. But there is we need to wait for the new Minister of Culture and the new Minister of Administration and Home Affairs, because it's a matter of affecting local authorities. Dorota Głowacka and Adam Ploszka wrote an article about local government expenditures. That's the easiest way to do it, being precise and finding out what local governments can spend their money on. Once it is clearly identified, we could easily solve the problem. So I can declare that I do understand the topic, that I'm willing to act, and I'll try to consider how I could use your assistance best. There's no need to convince me. Creating appropriate social and political climate around specific issues helps me in my everyday work, and I suppose that's pivotal. We simply should make these projects complete. Thank you very much. It was the icing on the cake of our conference. Thank you, Minister. I think it's the time to summarize our conference, which will be a major challenge because there were lots of important topics. I would like to invite co-organizers because the working group, including Article 19, Agora, Watchdog Polska, and Helsinki Foundation. Yes, I will summarize the conference. I would like to thank you for your cooperation, for making it come true, for organizing 2 days of such an international conference, and for inviting so many SLAP experts. I do hope that each of us is going to take something from this conference. I have lots of notes. It's our role of watchdogs. We are going to take your word, keep an eye on you, and remind you that civic society should regularly support you and help you. Thank you very much. Enjoy your weekend and see you soon.